Well, I did have a slip and fall, but it wasn't from around here. It was just a few weeks ago, and I was up north flying, and there was some real bad weather, some snow and some ice. And at first they said, you were not going to fly. And then they said, yeah, you are. And they walked us all out to this small plane on the tarmac. And we sat there for a while. Then they finally said, well, we're not flying after all. And so we were all walking back in, and this place was covered with ice. And I slipped and fell and shattered my elbow. I didn't know how bad it was immediately, but as time went on, I could tell it was really, really bad. I've just got out of one surgery. I'm going to be having more. I guess my question is there anybody liable there? Is it the airport? Is it the airline? And what kind of options do I have?
Thank you for your call. What are his options?
Well, I think there's a couple ways that you can prove liability in a slip and fall or trip and fall, and one is if they put the dangerous condition there, and if it's ice, maybe they didn't put the dangerous condition there. The other way is if they knew or should have known about the dangerous condition. But Harry, this is even a different type case, and I've seen people show liability where the business leads a person to a certain area, like at a oil change place. They say, hey, come here and look at your carburetor, and they make them walk through the oil and they fall. So you want to talk about how they can prove liability?
Sure. I've even had cases where someone has fallen into a pit at an oil change store. But yeah, first thing you have to look at is your status. Obviously, if you're an invitee and you're there for the benefit of the business and you're there as a customer, they owe you a higher duty than, for instance, if you're a licensee or even a trespasser. If you're a trespasser, there is no duty whatsoever that they owe to you. But if they cause the dangerous condition, like someone at a store who mops and doesn't put up a sign, certainly they're liable. Or if they knew or should have known about the condition, they have a duty to warn and to take care of the situation and to fix it up, at least to warn you, if not repair it.
And so you say knew or should have known, and I think the way you normally prove that is by the length of time that the substance was on the floor, and you can prove that a lot of times with like a surveillance video or other witnesses, or sometimes just the length of time, maybe if the the food looks like it had been trampled through several times. But videos are very important in that situation.